Spectrum wants to hear your views. You can SMS at any time during the show. Type Spectrum, leave a space, type in your contribution and name, then send it to 7197. Your views, our interviews on Spectrum, Radio 1 FM 90.
Hello, a very warm welcome. This is Spectrum on Radio 1. I'm your host, Edmond. On Spectrum tonight, inside of Parliament, what is the latest about efforts to recall Parliament on the oil and gas sector? The quest for a thorough debate in Parliament about the Ugandan oil sector took a twist on Wednesday when the Speaker of Parliament, Rebecca Kadaga, tasked petitioners to furnish her with issues that they want to discuss. Moving under Article 95, Section 5 of the Constitution, a team of MPs collected more than one-third of the signatures required to petition for a recall of Parliament. This Article 95, Section 5 says that once the mandatory signatures are realized, the Speaker shall, without hesitation, call Parliament from recess. But Speaker Kadaga insists that the petitioners must explain what they want Parliament to handle and justify if at all the matter is of an emergency nature. The Speaker also confirmed that Parliament is in possession of some oil agreements, but stressed that she's not at liberty to make them public or avail them to any MP just like that. Quoting Clause 59 of the 1985 Petroleum Act, she argued that no group of people other than government officials may access the agreements without the knowledge of the licensee, that is the oil companies, adding that if the MPs want the agreements, they must be ready to take an oath of secrecy. This standoff has prompted a debate about access to information, with the public wondering what type of information the government is legally mandated to keep out of the public domain, taking into account Article 41 of the Constitution on access to information. So tonight we ask, what are the chances of the parliamentary call taking place, considering the Speaker's position now? Also, what are the implications from the perspective of access to information if government refuses to make public the required information about the oil sector? Our guests tonight, Hon Winfred Niwagaba, member of the Legal and Parliamentary Affairs Committee. You're most welcome, Hon Niwagaba.
Thank you, Edmond, and good evening, listeners.
We are also joined by Mr. Frank Tumusiime, advocate from the Advocates for Natural Resources Governance. You're most welcome.
Thank you, and good evening, listeners.
We are also joined by Mr. Ngabirano, Development Law Associate. You're most welcome.
Thank you, Edmond. Good evening, listeners.
Hon Niwagaba, you collected enough signatures and petitioned the Speaker to recall Parliament. Yesterday she answered you, saying through the media, asking you to provide more detail about why you want parliamentary call. She says she needs such details to be able to plan. Why did you present a shallow petition to this lady?
Yes, thank you, Edmond. One, we did not actually present a shallow petition. In the first place, we moved under Article 95, Sub-Article 5 of the Constitution, which only requires us to get a third of the members of Parliament signing, requesting the Speaker to summon Parliament. The article is silent on why we would even want the Speaker to summon Parliament. But for us, we went a step further and said, we want you to summon a Parliament to discuss matters related to the oil industry. And she wrote back requesting us to show how emergent that matter was. We wrote back to her, explaining to her that the article under which we moved did not require us to show any element of emergency. We thought she had misconstrued that article with one of the rules of Parliament, particularly I think it is Rule 16, which gives her a discretion on her own volition to summon a Parliament when there is a matter for emergency. So we tried to distinguish for her Article 95, Sub-Article 5 of the Constitution and this particular rule. We were of course surprised when we read in the press yesterday and this morning that she insisted we had not presented a proper petition. Now, although we know we are in the right in the manner we moved, we decided, because we had already drafted the motion anyway, for which Parliament would debate, but under our rules of procedure, we would only be required to present it 3 days before the sitting of Parliament. And in our letter of yesterday to her, we had requested her to tell us when Parliament is sitting and the date and time, so that we lodge our motion in time. But because we have a lot of respect for the Right Honorable Rebecca Kadaga, we said, okay, today morning our group sat and signed the motion and went around 1, presented it to her, gave a copy to the clerk to Parliament. So we are waiting for her to act in accordance with Article 95, Sub-Article 5 of the Constitution. There is one matter I want to clarify. I'm told she said you go to court if you do not want to agree with my decision. One, we are not going to court, because there is no reason why we should go to court to have an interpretation of a very clear and unambiguous provision. And two, the provision says calls Parliament in 21 days. Even if we were to go to court, you would not have a remedy in 21 days. And moreover, as we speak now, the Supreme Court cannot sit as a constitutional court because it has no quorum. So even if we were to go and win in the lower court or lose in the first court of first instance, the Court of Appeal, we would still not have a petition heard. But that aside, our position, especially those who are moving on this motion, is that we are not moving backwards. What we want and what we presented in the motion today must be addressed one way or the other.
Well, but her spokesperson, Helen Kawesa, was quoted today in the international media as saying, forget about it.
Well, I don't know that she talked to the speaker, because we met the speaker around 1. From 1 to 2, we were in her chambers, and we agreed that we give her time to look through our motion. It has something like 10 or 11 prayers, and we are waiting for her response tomorrow. But even then, we have decided to call the members of Parliament who appended their signatures to our petition, and those members of Parliament who did not have the opportunity, for one reason or the other, but feel they agree with our position, to attend the meeting on Monday in the members' lounge at 11 a.m. I hope you allow me to make this announcement.
Go on.
For free at 11 a.m.
Go on.
For us to brief them on where we have gone so far, and depending on the response we shall have got from the speaker, response or response, we will agree with the members to see what action to take.
Mr. Tumusiime, talk to us about this scenario. How should the ordinary person read into it?
I'm very, very happy with this development. One of the challenges that we've always faced in this country is because of, especially even some writings I've made, is because of the role of Parliament in the oil and gas sector. I salute all MPs who have appended their signatures. I call upon those who have not yet signed to really come up and join this cause. And of course, I even call upon citizens to endear their MPs, respective MPs, to participate in this whole debate. But then, what is the cause? You see, these agreements, number one, I must state that Parliament has a very crucial role in as far as oversight and ensuring that oil and gas resources are managed very well. You want to look at the Constitution and also the oil and gas policy. Actually, the oil and gas policy is very, very strict, instinctive and clear on the chapter of institutional roles. Parliament has to really see that revenues are managed very, very properly. But then, what is the cause of all this? To my recollection, the first oil production sharing agreements were signed in 2005.
Yes, and 4.
Thank you.
The first
2004. Yeah.
Okay. July 2004.
Thank you. The one I've read is of 2005. But then in 2009, I was in a conference with members of Parliament of the Natural Resources Committee. Of course, some openly said they had not accessed the agreements, and then one of them said they had accessed the agreements. Of course, by then I was even seated with the chairperson of the Natural Resources Committee. She said, no, I've just got them, they are here, and I'm going to avail them to you. This is 2004 when an initial contract is signed, and 2009, that's when they are being availed to Parliament.
5 years later.
Remember the oversight legislative role of Parliament in ensuring that public resources are managed properly. But then, look at other limitations of Parliament. In Ghana today, the Oil Revenue Law and even the General Resource Management Law, Parliament is supposed to approve all contracts. The moment you're going to sign a contract or an oil agreement, Parliament must approve. And of course, I must again appreciate the challenges of Parliament. For example, you have capacity constraints, then you have ruling party politics where, there are two perverse that at times ruling party members just rubber stamp executive policy. Then you have also manipulation. But most importantly, Parliament are being denied the right to access information. It is too absurd. Section 59 of the Petroleum Act, of course, is so, in my view, so backward. Remember, today we have what we call international best practice. That is, in the oil and gas policy, you hear that Uganda, promises to implement the Extractive Industries Transparency Initiative. Yes. This initiative virtually means make public all revenues.
Yes.
From oil companies.
Yes.
Then now make public all expenses that you pay out of this.
Yes.
And of course, then they say contracts. Make contracts transparent. Avoid contract confidentiality. But you see, I must state that the origin of this is that, you see, the entire value chain in the oil industry starts with bargaining power. The moment there is no capacity to bargain, you are going to award a wrong contract. Then the exploration, production, and eventual revenues will all be affected.
All right.
So today, Parliament is at the right grip, and I'm so excited.
But Uganda is not yet a member of the EITI.
Uganda has not even indicated a sign to sign up to the EITI. That is the most unfortunate thing.
Briefly, can you talk to us about, you said there are capacity constraints with Parliament. What are those?
No, you see, there are capacity constraints, for example. There are also certain researches we've made and also literature that is available. Number one is it's a new, oil is a new resource.
Yes.
And not everyone will have the capacity to really understand and appreciate. But on the other, of course, the disappointing thing is that I've had occasion. I have a project with MPs, so some of them don't bother
to read.
Some of them have never come across an oil and gas policy. An MP will ask you, "Is it existing?"
Okay.
So that's another problem: attitude and capacity, and of course, manipulation by the executive.
We'll talk about that. All right. Mr. Ngabirano, is there a situation where government, the executive, would hold information from the legislature?
First of all, I would like to say that it's quite absurd that we have such a scenario happening. In most recent times, of course, we've had the scenario of journalists seeking to access this information, who went ahead to actually institute a petition, but it was very unsuccessful. And now we're again confronted with the issue of members of Parliament not also being able to access these production sharing agreements. And to me, I think the problem is actually lack of a culture of observance of rule of law, because Article 41 of the Constitution clearly grants each and every citizen, not only parliamentarians, not journalists, not any special category of people, the right to access information in possession of government, in possession of the state. And clause 2 of that same article provides for only two exemptions, and that is where the disclosure would prejudice state security or sovereignty, and two, where it would interfere with another person's right to privacy. So clearly, of course, the confidentiality clause is being cited as being reason for not granting access in this case. And of course, Section 59 of the Petroleum Exploration and Production Act of 1985. But we should remember that the 1995 Constitution brought a new constitutional order, and to that effect, all laws were required to be construed to reflect the spirit of the Constitution, which I take that the Petroleum Exploration and Production Act should have been construed. And even then, any law that contravenes the spirit of the Constitution is void to the extent of the inconsistency. So I would think that in this scenario, of course, Article 41, which guarantees the rights of citizens to access information overrides, but also maybe to state, particularly to Parliament, that courts of law have actually come out previously in of course, the authority of Zachary Room, which was a case that concerned, again, access of MPs to Hansards, parliamentary Hansards. Remember that during the scenario of the 2000 Referendum Act, and the court came out expressly to state that members of parliament have the right to access information like any other citizens. So I think it's very absurd, and it tells a lot on our culture of rule of law and good governance.
Hon Niwagaba, can you give us some of the details in this petition that you sent to the Speaker today?
Yeah, thank you. There are various prayers, but the first one, point number 1, is that we are requesting Parliament to put a moratorium on the executive arm of government from executing any other agreements and contracts related to the oil industry until it has put in place the relevant laws to put into effect the existing oil policy. And we want Parliament to give the executive only 30 days to bring those laws. Because you see, the biggest problem we have is money is being collected, money is being spent, and nobody knows where it is coming from.
There's no transparency about the money
at all. 2, we have also asked Parliament to make an order to government to account for all monies they have received under the oil industry in terms of license, signature bonuses, royalties, and taxes, and tell us from which particular companies and in which blocks all this money has come from, and actually tell us how many companies you have signed agreements with. And 3, we want also an account of the expenditure of the oil revenues, because none has ever been reflected in any budget to the best of our knowledge. Where is this money? We want that to be done in 7 days, if Parliament agrees with us.
Yes.
The other prayer we have is for government to actually produce to us all the agreements. There is an agreement they made with Heritage,
yes,
in 2004, in July. There is another one in September 2004. Now, I'm told they gave some agreements to Parliament in 2008. But there is a supplementary agreement we are made to understand they made last year in October 2010. Then there is also a memorandum of understanding government made with the RIA and Taro in March 2011. So when we are talking about these things, we know why we are asking for them. So we want all the agreements they have made with all these companies. And we want to verify that actually these agreements comply with the Constitution. 1, we do not want any agreement with a confidentiality clause. Government has no business in keeping secret matters which are supposed to be for the benefit of its people. Secrecy in such agreement is actually a symptom of bad governance. 2, recently the High Court Commercial Division made a ruling in respect of an appeal between URA and Heritage concerning the dispute on taxes. And the land judge held that the matter of taxation is a matter of statute, not a matter of contract. So why should there be an arbitration on an issue of taxes? And moreover, outside this jurisdiction. Now, there is also another clause which has done in one of the notices for arbitration by Heritage. If you read that clause, you would say, now God forbid. It says, if government makes laws or regulation that would affect the profitability of these oil companies, and you know, the profit they are talking about is our oil.
Yes.
Because all the money they are spending, which we don't know, will be part, actually the first deduction they will make when production starts. But once anything is done, including the laws we are supposed to make, which we have not made, those laws are subject to these agreements executed between the government and these oil companies. In other words, these companies are not supposed to make a loss. They are not here to make any losses. If they make a loss, the government is supposed to indemnify them. We are saying, for evidence sake, if there is any agreement with such a clause, make sure it does not exist. And other matters. So, and of course, we have also looked at the issue. There have been allegations in the press that money has been changing hands in the form of bribes,
yes,
by some of the officials on the executive arm of government.
Yes.
We want the government to set up a commission of inquiry and make its report to Parliament. We actually, our whole purpose is one, to have the law in the press,
yes,
and to have transparency in the activities of this sector.
This is Spectrum on Radio, and tonight inside of Parliament, what is the latest about efforts to recall Parliament on the oil and gas sector? We'll be back after this break.
Is your internet provider turning your world upside down? Broadband Company offers fast and reliable internet solutions. And for the first 100 subscribers this month, we offer zero connection fees. Save up to 400,000. For more information on these offers, call toll-free 0800 222 111.
Broadband Company, more than you expect.
Even back when I met George, I noticed something different about him. Maybe it was the way people looked up to him, or maybe it was his willingness to always help. He struggled at the start, and today he is a successful bar owner. Despite his success, George didn't forget where he came from. He built friendships with his patrons and learned from them as much as they learned from him. He used his business acumen to help many others achieve their dreams. The fact is, many people owe their success to him. But George never talks about it. He's just who he is. Special.
So here's to men like George who make a difference, who enjoy Now Special, the rich, satisfying taste from the source. Now Special, you've earned it.
Not for sale to persons under 18.
Spectrum on Radio 1 FM 90 is brought to you by Stanbic Bank.
Welcome back on Spectrum tonight inside of Parliament. What is the latest about efforts to recall Parliament on the oil and gas sector? Our guests tonight, people who would know. Honorable Winfred Niwagaba, member of the Legal and Parliamentary Affairs Committee, Mr. Francis Tumusiime, coordinator, Advocates for Natural Resources Governance, and Mr. Ngabirano, Development Law Associates, also a lecturer at Makerere University. You'll be able to contribute to this discussion at some stage. Let's look at this confidentiality clause. Mr. Tumusiime, how do we get out of that?
Honorable Niwagaba mentioned the necessity to enact an oil revenue legislation. Of course, you know that normally the speed of oil production normally surpasses enacting legislation. One way to overcome this is to put a law in place on, for example, transparency. And of course, because Uganda is new to this industry, we always have to borrow from international best practice. I'll endear all Ugandans and even the executive to copy an example of Sao Tome and Principe. They have a very good law. For example, it states clearly that, well, there can be confidence of some commercial information, but any confidentiality clause that touches revenues, money originated from oil, is void ad initio. And we're talking about revenue transparency here. If there's no money, if we can't account for the money, we can't even know how to utilize it to out and reach other sectors.
Okay, let's come to Mr. Ngabirano. If for instance, Parliament took an oath of secrecy